2 of our podcast, Implicit Bias, on trial.
How did you deal with that when you were practicing and trying cases? What's the secret sauce there?
I don't know if there's actually a secret sauce, right? You, Bryce. But I think you and I both know that we become the avatar for our client. Okay. So I suppose a secret sauce is being the nicest person in the courtroom, the most respectful person in the courtroom, so that regardless of the fact of me, what I am trying to establish with them is kindness, generosity, professionalism, respect for everyone. And then that benefits my client regardless of who they are. So I know that's what you do, right?
Yeah.
Okay. So I did the same thing. Here's the other thing I think also I'd be happy for you to disagree with me, but I don't think you will. Okay. You're looking in telling your story for your client for an access point with the jury. And my belief is that we want to tap into accessibility bias in the story. What is it about a story that I can tell you that is a lived experience you've already had? And you hear the story and you go, I know exactly how this goes. And I already agree because of the story. And that helps deal with, I feel negatively about either you or your client over there. So those, I think, are the secret sauces, right?
Yeah, it kind of goes, it's basically really kind of doing judo on implicit bias, right? Trying to flip it and say, one of my favorite books is the Sneetches by Dr. Seuss, about some Sneetches had stars on their bellies and others did not, and then the ones that didn't were like, oh well, we'll put a star on ours, and then that made it confusing because then you couldn't tell who the good guys and the bad guys were, but turns out they were all just Sneetches.
Right.
And in trying to create a connection, a shared connection between the person on the jury and your client, right? That is, I think in every case, that's certainly part of the secret sauce, but even more so when you've got clients who you worry are going to have an incredibly deleterious impact from implicit bias. And I think, the other thing we haven't talked about that was just occurring to me as we were having this conversation was back in my PD days, public defender days. One of my good friends is Phoenix Streets, who's still at the office and really great lawyer. He's African American, and he and I would frequently talk about our cases, and he would frequently have me come talk to his clients because his clients that were African American also had an implicit bias, and it was that they would do better if they had a white lawyer, particularly a white male lawyer, to be frank. And it didn't matter how much I said, this guy over here is 10 times better than me. Like, you're doing great. It largely wouldn't move the needle much. And that's kind of an interesting piece of our whole legal profession as well, in that, we all feel like, we made it wherever we made it, just working hard and doing the right things. And, this American illusion of the self-made person. And it turns out that some of us, I think, whether we like it or not, had some breaks, a lot of which we probably didn't know about because of implicit bias. And a lot of people, conversely, didn't get a lot of breaks because of that same thing.
Agreed.
And I don't know how we break that down.
Well, I love your story for two reasons. One, I hear from time to time a response before I get deep into a presentation, or I perceive it, that I'm only talking about people who are not Black, for instance. And then I go, oh, by the way, the science tells us that Black people have the same implicit biases against Black people. Okay. Just as about every other group in the groups that you can test have implicit biases against their own in-group. Old people don't like old people. Go figure, right? And as far as the rest of it, you know about the halo effect, right? Well,
The halo effect, yes.
right.
Yes.
This is the one where someone is so extremely attractive for whatever reason that everything they do seems to glow, right? And people can step within the halo and they start glowing too. And why is that? It's because of the implicit biases that favor this image, which is why it was better to have a white man lawyer. But also telling a story about the strength of these beliefs of Black incompetency when it comes to something very difficult and very intellectually challenging, like being a trial lawyer.
Yeah. Unfortunately, it didn't help Jim in To Kill a Mockingbird, but it's the bias is the same nonetheless, right? It's so this is interesting. So I kind of like the route we've taken here. You've really helped, I think, put a fine point on what this thing is, how we've all got it, what the science is, some of the challenges that we all have with it personally, and some of the things we can do to work against it. Maybe we can shift gears now. I'd like to hear your thoughts on how implicit bias, from your perspective, has created challenges within the system itself to getting justice.
Okay.
So, and maybe wherever you want to start, I love trials, so jury selection is one of my favorite things. But if you start wherever. See, now I've just primed the pump. Now you got to talk about it, but you don't have to talk about it first. You can talk about it second if you want.
Fair enough. Fair enough. Well, all right. I used to have a problem saying justice system. I say it now versus legal system. My thought was always, okay, justice isn't a system. Justice is an action that people do. So a legal system is a system of laws. Laws are laws. Whether they are just depends on the people who apply them to other people. So justice is this human activity. So necessarily, why people do what they do within the justice system is consequential. So how does it fold in? Well, we've talked about a lot of ways how it folds in. This almost instantaneous. And I say almost like, picoseconds until that judgment kicks in, right? Okay, almost instantaneous response to what is happening in front of you. Just because you go into a courthouse doesn't make it stop. And in fact, there are studies that show that it's activated in ways that are disheartening and challenging. For example, you know about the instruction that is given to presume innocence?
Yes.
Okay. There's a study that says primed for guilt is the name of the study. And what it shows is that there's a potential that the innocence instruction, depending on whether the crime is a violent crime, because of the association of Black people with violent crime, in those cases, the innocence instruction primes jurors, mock jurors, to look for Black people. The next step that the authors don't take is that instruction actually primes the jury to doubt the innocence of the defendant. Because it's tapping into the implicit bias that causes that person on the jury to give me a very wide berth as they walk past me in downtown Columbia, Missouri, right? One of the most profound places I saw a question on your face.
Yeah, no, go ahead.
One of the more profound places that it has been allowed to operate and nay prosper is jury selection. So you know the history of juries in the country. I won't get deep into it. And the time was, it was important to know for the juror to know who were the parties, who was representing the parties. And this time is back in the 1700s, early 1800s. And over time, as communities get bigger, and it's very difficult to know truly the reputation of the people, then we decide the jury should know nothing so that they can be fair and impartial. Okay. Initially, this thing called a peremptory challenge, right? So, as everyone knows, if you can't be fair and impartial, and that's obvious, you can't sit on a jury, and you're stricken for cause. That makes sense. Okay. But there's something called a peremptory challenge, where any lawyer who has the right to them can strike a juror for any reason, and they don't have to say why. Okay. Did you know it was originally only a tool for the defense? And it doesn't become a tool,
For the criminal defense?
For the criminal defense.
Huh. Did not know that.
Yeah.
I like that. Can we go back to that?
No, that's a little too far back in time. A little too far back. For prosecutions in criminal cases, the peremptory challenge starts to flourish in the aftermath of the Civil War. Okay? So what has happened? Well, now Black people are allowed to sit on juries where they hadn't been allowed to sit on juries. Okay? Hate to say it this way, but how do we stop it from happening is the thinking. Okay? Oh, well, one of the ways is to allow prosecutors in criminal cases to have and use peremptory challenges. Let's do that. And so they do that. And then the evolution of our history at the time, from Civil War to Reconstruction to the period called Redemption, where home rule in the South reasserts itself, right? To a point where we have, by statute, by law, the exclusion of Black people from juries, which gets us to a case from 1878, Stouter versus West Virginia, where the United States Supreme Court says that violates the 14th Amendment of the Constitution. You can't write that in a statute.
Right.
Okay?
Be more creative.
And the instruction is heard, and the creativity ensues. A variety of other things happen to keep Black people out of the veneer, the group of potential jurors, right?
Yeah.
But one of the things that is always going on is peremptory challenges. Yeah. Then we get to the Swain case, 1965, where we get a description of what peremptory challenges can be used for, and there's even language in the opinion that says, yeah, in the ordinary course, these would have nothing to do appropriately with a trial, but you can use your peremptory challenges based on race, ethnicity, national origin, etc. Yeah. And here we come to 1986 and Batson, the famous Supreme Court decision that says We're going to analyze the use of peremptory challenges now under a three-part test. Thurgood Marshall's concurring opinion. Thurgood Marshall wanted peremptory challenges done away with in its entirety in the federal system because his belief was either they're going to be used for purposeful discrimination or implicit, unconscious discrimination. He uses the word unconscious. This is 1986.
Yeah.
Okay? Before the explosion of implicit bias knowledge. Here's how it's going to be used. And it turns out that he was right. And that's based on all of the studies of how effective has Batson been. And I guess you have to accept that if the challenge is sincerely asserted against a peremptory strike of someone who is, let's just say in this instance of the defendant race black, right? If that challenge is asserted for the right reason, and there are good arguments behind it, then you would see more successful Batson challenges. And the reality is there have been almost no successful Batson challenges.
Yeah.
In Missouri, which adopted Batson through a case called State v. Antoine in 1987, between 1987 and 2022, out of 48 Missouri Supreme Court decisions, 2 gave the defense a ruling in its favor on a Batson challenge. Okay. So what's happening as people are making these decisions? Call it my gut, call it my intuition. I'm looking at someone and I'm going, I don't want them on my jury. I may not consciously say to myself, because they look like the defendant. But I'm reading their face, I'm reading their demeanor. And one of the things we know from the science is, if you're looking at someone who you have an implicit bias against, you're going to read their demeanor much more negatively than is justified by the facts.
Well, and we know that from all kinds of, like, we've already talked about just on this podcast, some of the science behind that, right? Like go back to your example of the 2 clients who walk in, one who's attractive and the other who suffers from being overweight, who's black. If you can eliminate all those visual cues, you get very different results. And if you sometimes we even have to eliminate the auditory cues, right? And I think the same is true when we're picking these juries. If it's very hard to stop using your senses when you know that they're deceiving you sometimes, not intentionally, but implicitly.
Well, this goes back to the basic point, Craig. You're not able to consciously say to yourself, my senses are telling me things that I should ignore.
Yeah.
That's not how it works, right? You're in the moment, you're doing what you're doing. I don't care how well you primed yourself. Well, I do care. Okay. Once the shooting starts, right? You're now in a place where you have to move much more quickly and you're more apt to rely on stereotypes. I don't matter how many graham crackers you ate before you started selecting that jury. Okay.
Yeah.
So it's just that automatic. We will never be any good at self-evaluation when it comes to these things, but we can become very good at evaluating the decision-making of others. Okay.
Yeah.
Which is, in a way, problematic.
We're good at being judgy.
Well, yeah, and good at rejecting the fact that the same judgments should apply to us. So one of the things, other than hoping, in Missouri, you're required to have part of your CLE some kind of, for ethics purposes, some kind of cultural competency or implicit bias training annually. Okay. I talk about the test all the time. People don't take the test. Repeat players. I've seen you here at this presentation before. Did you take the test? Nah.
Yeah.
Okay, good to see you.
Yeah, right.
So on the one hand, we're trying to train people. And on the other hand, we still have to think about, what about the jurors? Right? So should we do something about them? Should we give them information about the existence of implicit bias and how it works in a jury instruction?
Yeah, and we do have that here in California. We have an instruction on implicit bias.
Okay.
Um,
We've got one too. An interesting one. So the broader history on that issue is that as the implicit bias awareness, I'll call it movement, develops, and the American Bar Association gets involved with a bunch of people who have spent a lot of time thinking about these things. I mentioned Mark Bennett, Jerry Kang from, I think, UCLA, puts together an implicit bias primer for the federal courts, and then they developed an implicit bias jury instruction, which the key takeaways, I think, are it talks about we, and here's the judge saying, we have this thing. It works on us in this way, and we need to be mindful of that in order for justice to be done here. It's a great idea. Okay?
yeah,
Our instruction in Missouri deletes all of the we, which was there to make sure that the jury understood that the judge is saying, I have it too.
yeah, which is powerful, or at least has the potential to be more powerful.
Right,
Yeah.
right. And so some colleagues and I studied the Missouri instruction to try to understand what's the takeaway people that we would reasonably expect to be on a Missouri jury. How do they understand this? The good news is that they all accept the existence of implicit bias. They all agree that they all have it. They all agree that this is important to do. The bad news, they all decide, but in reality, I don't have it because in my function as a juror, I know I'm not supposed to. But I'm worried about the other people in the room with me because they still have it.
Yeah,
It's this weird nullification that happens. The judge just told you. You in your mind say, yeah, I've got it, but then you nullify without anybody knowing. I don't have it. I don't need this. Someone else's problem.
right. Well, and sometimes we need to sort of be shocked into the reality, right? That I'm thinking as you're talking about this, I'm thinking about A Time to Kill and Jake Brigance at the end of that movie, talking about this horrific experience that this little black girl has gone through, his client's daughter. And he asked the jurors to listen to that story. And then at the end says, now imagine she's white, and everybody's eyes open in shock, which drives home the point that you were thinking about this differently by virtue of the color of her skin. That is the only reason you had a slightly different, or were even considering, what the prosecution was saying in this case. But when you turn that little girl into a white girl, the way people think about it changes. And when you see it in your mind's eye, which is what he was trying to drive home, of course. And I think that's an interesting lesson for us all, that, it's good. Like, these tests aren't just good to take. Like, you should take them time and time again, every so often. It's almost like going in for a physical, do it once a year. See how you're doing. See if anything's changing.
Right. Is the strength lessening?
Yeah.
Okay.
Right. Yeah.
Yeah, I love the example that you just gave, and as far as using knowledge of implicit bias as a tool, right?
Yeah.
Exactly a thing to do. I mean, it's going to take an excellent trial lawyer, right, to have thought through how am I going to get the jury to revision who has testified, who the victim was, who the perpetrator was, to test do I already have conclusions about what's happened here because of how somebody looks? Would they be different if they looked like me?
Yeah. Yeah. It really, it's incredible how powerful it is and yet subtle all at the same time, right? It's this thing that just sort of creeps around in our brain, mostly, hidden in the shadows until you can find, until it's, and every once in a while we do find a way that it gets, in thinking about analyzing cases, when we're talking about the systemic problem
Right.
within our legal system or justice system, as one might, when I was a public defender, of course, we called it an injustice system. But if district attorneys, when they're evaluating cases to charge, could strip out all of the information that identifies anything about the person that is being considered to have charges against them, I think that science tells us very clearly that we'd have very different charging decisions. For one thing, there'd be a lot more police officers that would get charged than don't, right? So if you just took out the information that what you're reading about was by a police officer, changes the way in which they see the case, but even more so as it relates to color and gender, and myriad of other, immutable characteristics that we have.
Any other extraneous information. So about the studies done about on bias in orchestras.
Yeah.
Right.
Yes.
So used to be that if you were going to be in a professional orchestra, you had to be a man. Very few women. Then I believe, what is it, the New York Symphony? Some famous orchestras decide, okay, here's what we're going to do. We're going to take the visual cue away and let the jurors of whether this person should be in the orchestra just listen to the music. Okay. In the first tests, they forgot to lay down a carpet. And so you could hear that it was a woman because of the heels. Then they lay down a carpet. Okay. And at that point, we start to see the proportions we should see of women professional musicians in these top class orchestras, because all of the extraneous information has been weeded out. It's how good can you make that instrument sound? That's what's important. Just like what you're saying, if the people involved in making, I guess, the most consequential decisions in a person's life didn't know anything about what did the person look like, where they live, and only knew what they are alleged to have done, would they make the same choices in terms of charging? And I think the answer scientifically has to be no, particularly if you strip out all of the identifying information from everybody in the file.
Yeah. And again, it's typically not, look, I dealt with a lot of prosecutors, and by and large, I think most of them were trying to do their job to the best of their ability. They weren't doing it because they had animosity towards people of a certain color or gender or sexual orientation, any of that, right? Like, I think that wasn't why they were there. It just didn't change the fact that the way they saw the world was greatly influenced by implicit bias, which then had an adverse impact on people who came from certain backgrounds. And
absolutely,
it's really hard.
There's no way to say that those people are bad people.
No.
Right?
No. But I do think that is part of the challenge with this whole thing, is that it can feel very much like an attack on individuals.
Right.
And it's actually just an attack on that creepy crawly thing that's walking around in your brain in the shadows that you don't really know about, and trying to make sure that thing isn't the thing. It's the thing that the person you think you are is actually the person making the decisions. And the only way to do that is to get rid of the thing that kind of lurks in the shadows.
Right. And because we can't get rid of it, so other alternatives, particularly as it comes to who should be on a jury in this peremptory challenge business, is should it be allowed at all? Or should the kinds of things that someone says, oh, here's why I struck that person, are those correlated to and stand-ins for, I struck them because they come from poverty and it's a crime-ridden area. I struck them because, they've had encounters with the police that didn't go well. I struck them because, they don't speak English as a first language. And that means something, right? So California has a rule like that. I think one of the more famous ones is Washington's General Rule 37, with an itemized list of reasons that are presumptively invalid, because Washington has decided, all right, these are stand-ins for implicit bias, and we're not going to give rein to it. Okay.
Yeah.
You can still use your peremptory strike, but you can't do it for this reason. And the one state in the union that has outlawed them, Arizona. And they had good reasons to do it and good data that showed disproportionate numbers of Hispanic people, Black people, Native Americans were being stricken, and juries were largely overrepresented by white people. They get rid of peremptory strikes. None of the cast of horribles occur, like, there's going to be mistrials right, left, and center, and criminals are going to be allowed to roam free. No, the results have largely been identical, with peremptory challenges and without, with the benefit to justice of more balanced juries.
Yeah, greater participation. Yeah. Well, and do you have, on that point, do you feel differently about the use of peremptory challenges as it relates to criminal cases versus civil cases? Or do you feel the same way, that maybe in both cases they should be eliminated?
Oh, it's all got to go.
Okay.
Yeah, the stakes are much higher in a criminal case, naturally. You're talking about
Sure.
and liberty here. Okay. In a civil case, you're pretty much just talking about the third of the triumvirate property. Okay. How much am I going to get, or how much are you going to owe? The jury's decision-making is going to be influenced in the same ways. The decisions of the lawyers are still being influenced in the same way. And so civil justice, criminal justice, it's the justice system. It should all be just.
Mm-hmm.
Why leave half of it tainted?
Right. I mean, I think if there isn't a way, I will say that my own practice in terms of picking juries has evolved dramatically from definitely from day one to now, but even in the first 5 years to the last 5 years, and I am far more, I used to have all those stand-ins that were all stereotypes and biases that I had to use didn't have to use, but I did use as a shorthand to try and get that jury, at least in my mind, to what I thought might be more in the middle, where I'd had a better shot.
Right.
Now I try to do a lot more work and a lot more listening to what people are actually saying about how they feel about things, than having any, I still have lawyers who call me up and they're like, I got such and such a case. Do I want engineers on that case? Do I want nurses on that case? Do I want poor people on that case? I'm like, I don't think I wouldn't tell you about any of that. I think you want to hear what they have to say. And if they don't believe in the tort system and you're asking for money, I don't think you want them. And I don't care if they're rich or poor. I don't care if they're black or white. I don't care if they're a nurse or a garbage person. So I think it strikes me as I am in, as I'm continuing to do trials, but also watching other folks do trials, there's become a recognition, not so much, I think, because people are as concerned about fighting against implicit bias as they are about getting better jurors and really understanding how jurors think. Because there are certain jurors that, are going to think in a particular way where they're not, they're never going to do what you'd like them to do in the case. So I think but that's a challenge. That's, I think my feeling is we need more jury trials, not less. The jury trials have been going downhill. I think we need more participation in jury trials by more jurors, not less. But I may not always be in the majority on those issues. So,
well, you're preaching to the choir here.
Yeah,
it's 100%. And the thing that you're talking about doing is this very effortful thing. Okay.
Yeah. No, it takes more time.
Well, but let's extrapolate from I'm doing it in selecting a jury to here's how I'm going to live my life. I'm going to encounter someone who's dressed a certain way, looks a certain way, and instead of I've already figured you out, I'm going to say, do you have a preference between Cheerios and graham crackers? Because I really like graham crackers, and I wonder if anybody else does. Or find something completely innocuous to start that conversation so that we're less reliant on what we think we know and we're gathering data.
Right. Telling a story based on what the person's actually shared with us and how they've interacted with us, as opposed to the story that relies on all those ticks or what are they called? Bugs.
Mind bugs.
Mind bugs. Yeah. Yeah. So, Professor, this has been really educational for me, even as somebody who's spent some time with this topic, and I hope the listeners feel the same way. I'm wondering if, as we're bringing this to a close, you have kind of what is the 1-2 things you would suggest people do if they're interested in this topic, both from a personal standpoint, but also from a systemic standpoint, that they could do that might help them both personally and help the system?
I think certainly the thing that we've been talking about doing, go ahead and find out. Go ahead and actually learn that it's there. Take the implicit association test, right? The idea being you wouldn't be making the choices you made because you don't have enough time to do it consciously. Therefore, when you're taking the test, it's your unconscious mind that's driving the bus. Great. Find out. Then when you find out.
By the way, the tests are in the links. Sorry. Now, we found out now.
Hey, when you find out, give yourself some grace because you're going to be shocked. Okay. Then start priming yourself. But above all, like what you and I were just talking about, Craig, take that next opportunity when you're in the Starbucks or when you're in the grocery store, some kind of environment that is completely safe. And somebody orders a drink, they look nothing like you, and you ask them, is that any good? And see the positive interaction that you have. That's another way to do the priming. Make an effort to have positive interactions, right? You don't start with, okay, so who did you vote for in the last election? Or even, how do you identify? Democrat or Republican or Libertarian, right? No. Let's human to human. This thing you're enjoying, I want to know if I enjoy that. How does it taste? Okay. If you accumulate those good experiences, you're going to be in a much better position to participate in the justice system. I don't care if you are a juror or a lawyer or the judge or the bailiff or the clerk or a witness or a party. That's going to benefit everyone and make more justice. And we can do it. But it's that effort, like that one step. This is a complete stranger that I'm going to ask, how does that drink taste?
That's awesome. Thanks, everyone, for listening to The Rule of Law, The Academy Speaks. Thank you particularly to our guest, Professor Chuck Henson from University of Missouri School of Law. We really appreciate you being with us today, doing these episodes, sharing all of your wealth of knowledge, and really helpful information that I think for people who who want to deal with this and who maybe know deep down that they've got their own implicit bias, because we all do. To really kind of give us the scientific context for it. I think it's been really helpful, and particularly for lawyers, as a means to be better lawyers, to do justice, as you just said. So please listen to our podcast, The Rule of Law, The Academy Speaks, on YouTube, Apple Podcasts, Spotify, or wherever you get your podcasts. We look forward to having everyone join us for our next episode. Thanks for being with us.